Hamilton.
Welcome, LA Progressive, friends, family, readers. Again, Dick and I are joined with Bill Blum. He's becoming our resident expert on all things Trump trials.
Yeah, yeah.
And we certainly appreciate it. So Bill Blum is a former judge and death penalty defense attorney. He's the author of 3 legal thrillers, Prejudicial Error, The Last Appeal, and The Face of Justice. And he's a contributing writer for the LA Lawyer magazine, as well as other publications, including Truth Dig and the LA Progressive. And we just are so delighted to have you joining us again, Bill. How are you?
I'm doing well, and it's always great to be here.
Yeah, so we wanted to talk about a piece that you published for Truth Dig, and you graciously allowed us to republish it. And we've entitled it, "The Supreme Court Will Not Save Us." And so let's talk about what the Supreme Court recently decided with Donald Trump and his immunity plea.
So with the immunity case, the court has scheduled to hear Trump's claim of absolute immunity as a former president with respect to Jack Smith, the special prosecutor's election subversion case that is pending in Washington, D.C., and now is stayed since the Supreme Court has taken it up on review. The court has scheduled the oral argument for the case on April 25, which is the last date for arguments on the October 2023 calendar. So they are slow walking this case, and that stands in sharp contrast, number one, to Bush versus Gore, which was decided from petition to decision in 4 days, and from Trump versus Anderson, which is the 14th Amendment Insurrectionist Clause disqualification case that the court disposed of in 2 months. Now, this immunity case has really been with the Supreme Court since the early part of December, because Trump's legal team originally made a motion to dismiss that prosecution in front of the trial judge, who's District Court Judge Tanya Chutkan. And they did that in December. And after Chutkan denied the motion, Special Prosecutor Jack Smith filed a petition with the U.S. Supreme Court urging the court to review the issue now in through a procedure called cert before judgment. It's complicated, but they wanted the Supreme Court to bypass the Court of Appeals because the issue was, a first impression issue and one very, very important to the legal and political history of the country. And of course, the court denied that motion, that request, but it did so only after accepting briefing on the case, which took up more time. So then the court sent the case back to the Court of Appeals, which held its oral argument and then took a month to write its decision, which it handed down, I believe, on February 6th. And then Trump's team and the court unanimously rejected Trump's claim of absolute immunity, which is absolutely absurd. And then Trump's team petitioned the U.S. Supreme Court to take up the matter, which they did. And they are not moving particularly quickly. In fact, as I have said, they're slow walking the case relative to other very, very important presidential cases that they've handled in the past and currently. So this once again shows, and this is the conclusion that I put forward and that others are putting forward, and that is that the Supreme Court is not going to save us from Donald Trump and the movement that he represents. We're really going to have to save ourselves. And what that means, fortunately or unfortunately, is that we're going to have to defeat Donald Trump in November. It's very, very important. People keep saying that the next election is the most important election in our lifetimes, and some people are getting tired of hearing that. Unfortunately, it happens to be true, and that's what we're faced with. And so that's the message of the article.
So I just want to slip back, and usually we flip back and forth. I do want you to talk about April 25th, the October and the relationship with October, and how it is that, people who are not lawyers, who have not gone to law school, sometimes they don't even understand the difference between an appellate court and a trial court. And oftentimes when we think of something being in the courts, it can take years to resolve, but that's a trial court. And so talk about the difference between an appellate court and a trial court, with the Supreme Court being an appellate court, and why
Sure.
that
So
April 25th date is so important.
When a prosecutor secures an indictment, the case goes before a trial judge. And in the federal system, trial judges are district court judges. So if you look around the country, there are many district court judges. And normally a case will proceed to trial, and there won't be any intervention by a higher court, any review by a higher court, until the jury reaches a verdict. But in this particular case, Trump's lawyers, who are very aggressive, seized upon an exception to the rule that trials proceed to judgment before an appellate court is asked to get involved in the case. And there are some exceptions to that general rule. One of them applies to motions that, if granted, would undermine the entire prosecution and render it null and void. So one issue that Trump's team seized upon was this question of immunity, the idea that the president, who represents one branch of government, the executive branch — we have three branches, the legislative, the executive, and the judicial — that the executive branch should have absolute immunity from charges that the president committed a crime during his time in office. So rather than wait for the case to go to trial and raise that issue after trial on appeal, in all cases, after they go to the jury and a jury returns a guilty verdict, then the defendant can appeal to the next level of court, which in the federal system would be our courts of appeal, our courts of appeals. And this case would go to the District of Columbia Court of Appeals. So Trump's lawyers filed what would be called an interlocutory, that is, an appeal before judgment, with the DC Court of Appeals. And the DC Court of Appeals had to decide a number of issues, including whether or not the interlocutory appeal was proper in this case, which it did. It said, okay, let's hear the appeal. And it eventually issued a decision on the merits of Trump's claim of absolute immunity and said, in essence, this is an absurd claim. Presidents are not immune from committing crimes. And Trump's legal team tried to argue that the same standard should apply in criminal cases as applies in civil suits against presidents. And in civil suits against presidents, there is case law that says presidents are immune from civil lawsuits when their acts are committed within the scope of their office, or what's said to be the outer perimeter of their official duties. In criminal cases, that's not the case. If a president violates the law, the criminal law, then after leaving office, that president can be prosecuted. So to put it into context, Judge Chutkan, the trial judge, set the trial date for March 4th. And that's why Jack Smith wanted to jump ahead and have the Supreme Court issue its decision in December so that that trial date could be kept, because the purpose of moving swiftly is to have Trump's trial well before the November election. But the Supreme Court refused to cooperate. It sent the case back to the DC Circuit Court of Appeals, which, as I said, issued its decision on the immunity claim in February. Trump's team then appealed, and the Supreme Court said, yes, we have to review this case. The Supreme Court didn't have to do that because under the federal system, you get one automatic appeal to the next level of courts, which would be the Court of Appeals. But thereafter, to go to the Supreme Court, you have to persuade the Supreme Court that your case is worthy of their involvement. So they have discretion to get involved. So the Supreme Court could have declined to review the matter at that point. It could simply have said, the Court of Appeals did a good job. We like what it did. We're not going to get involved. And in that event, Chutkan probably would have set the trial date for sometime in May, because there's still work to be done pre-trial to get the case prepared to go to trial. But now that the Supreme Court's gotten involved and it won't hear arguments until April 25, it's likely that its decision won't be handed down until the end of June, which means that at best, the case goes back to Chutkan sometime in July, and she will have to give both sides time to prepare, which will be required by due process. And so that means that the case probably won't go to trial until sometime in October or late September. And by that time, it might be too late to hold a trial that close to the election, because things will just be so chaotic with Trump running for president. So the Supreme Court, while on paper it might look impartial with regard to the absolute immunity claim, is in fact de facto endorsing the immunity claim because, and here's the absolute ace in the hole for Trump's team, if Trump is reelected, he will simply order his attorney general to drop the prosecution and the case will die. And Jack Smith's election subversion case will never go to trial. And in addition, the Mar-a-Lago documents case pending in Florida will also be killed and will never go to trial. That's the game plan. And he has a very, very compliant Supreme Court. And people have to understand the court is not on our side. It is on the side of Donald Trump and the movement that he represents. So we can't expect the court to save us. And even if the court ultimately rules that presidents do not have absolute immunity, and I think that they will so hold, it won't help Jack Smith's prosecution, and it will, in fact, help Donald Trump if he's reelected. Of course, if Trump is defeated, I think Trump has jail in his future. But that is up to us as the electorate. And right now, what you're seeing is Biden as the nominee of the Democratic Party, because this really comes down to Trump versus Biden. I think people have to get real and understand that. And a lot of people in the Democratic coalition, a lot of progressives don't like Biden for a number of reasons. One, he's quite old. There's no question about that. So is Trump. And two, they don't like Biden's position on Gaza at all. And maybe that'll change by the time of the election or as we get into early voting. But that's the choice before us. And just recently, Donald Trump, for people who are interested in Gaza and that war, Donald Trump has affirmed in interviews that he wants Israel to finish the job. So if anything, Donald Trump is worse than Joe Biden on the Gaza question. So that's your choice, America. And it's an important choice. Go with Joe Biden, who has done a lot of good things domestically and isn't a neo-fascist. And Donald Trump is, and the movement he represents, even more importantly, is neo-fascist. So if you don't want your country to move in that direction, it doesn't take that much energy, except in some places across the country, to vote. In California, you can vote by mail. You get a ballot in your mailbox, you fill it out, and you drop it off in a mailbox or a drop box for the your local election board maintains. So that's our choice. And that's the point of the article.
Yeah, so as you're saying, and as a lot of commentators say, the only believable way to the broad swath of American people is to beat Trump at the ballot box. And as you're saying, I guess I sign up for that, but also as you're saying, that makes me pretty nervous. But another fallout from this is Trump is once again beating the system. He's beating the odds. He's not just worse than Biden on Gaza. He's worse on everything imaginable. I mean, he truly is. I don't think he's leading a movement. I mean, I think he's just wrapped up into whatever he can say that sells. But is there a thin reed with the Alvin Bragg case in New York involving Stormy Daniels, which is a criminal case, right? Could if that goes to trial and came to a judgment, do you think it would make any difference in the election, or is there any way the Supreme Court could interfere?
I don't think there's any way the Supreme Court's going to be able to interfere with that trial, which is set for March 25. I wouldn't put it past Trump's lawyers to try to get it back into the federal system, but they tried to remove the case before. And the federal judge named Hellerstein sent the case back. He remanded it back to state court, saying that this does not belong in the federal system. I think it's a strong case, actually. Would it make a difference if there's a conviction? I think it might make a difference for a small number of people, and that small number may be important enough to help Biden in certain swing states. But when you said that we talk about the movement behind Donald Trump, the way I see Donald is that he's an instinctive fascist, meaning that he wants to be all powerful. And that's what fascist leaders crave. And even if he lacks the understanding of the political process and the legal system that say, we're talking about classic fascists like Mussolini or even Hitler had, he has people behind him who really do understand the way the system operates, like Stephen Miller. And so there's this perfect blend of people behind Donald. And those people, I don't think, will be swayed by convictions, by criminal convictions. They like Donald Trump, not despite the charges that have been brought against him, but because of the charges that have been brought against him. They like it that he tried to overturn the results of the 2020 election. But there will be some independents, some Nikki Haley voters who, if he's convicted, I think will either not vote for him or may come over and vote for Biden in the end. Now, what scares me most about Biden, and I was listening to a podcast that's run by a guy named David Pakman. It's an interesting podcast.
We know it.
And he had a psychologist named John Gartner on. And I've written about Gartner before because I wrote an article for Truthdig that they almost didn't publish, but turned out to be one of their most popular of all time. In 2016, July 2016, it's called The Psychopathology of Donald Trump, in which there was an emerging consensus by the mental health experts who were brave enough to speak out that Donald Trump was what we call a malignant narcissist. And John Gartner on this recent podcast with David Pakman was saying that Joe Biden has an old brain. I'm simplifying, an old brain. You can see that there are more gaffes than there used to be, but his judgment isn't impaired. But Donald Trump has a broken brain. And the theory behind that is that Trump is showing signs of dementia. And if you look at some of the footage from his recent rallies, there are moments when he has brain freezes.
Yes, we've seen that.
And he can't pronounce words, and he confuses Obama with Biden and Nikki Haley, with Nancy Pelosi, and this goes on, and it isn't just a one-off. This happens repeatedly. So this is pretty scary, but we have Donald Trump, instinctive fascist, who, if Gartner's correct, has a broken brain, versus an old man with an old brain, but whose judgment is still intact. So this is not a good choice for the country, but for me, the choice is clear. I mean, I would much rather have someone like Cornel West if he could possibly win, but he can't. So I don't entertain those fantasies. I'm not going there. This is too important. And I want people to understand that this is the choice in front of you. If you want a candidate who doesn't believe that climate change is real, go for Donald Trump. If you think that Donald Trump is suddenly going to become a peace candidate, vote for him. And Donald Trump's going to militarize the border. He's talking about invading Mexico to take down the cartels. He wants Israel to finish the job in Gaza, whatever the heck that means. Finish it, as though Israel's not finishing it already. If that's the sort of person that you think is going to advance your interests, then you'll get the president that you deserve. But I hope you deserve better. I think you deserve better. And that's the message of the article, because when we look to the Supreme Court, sure, this litigation is important. It has to be brought. We have to argue the cases, but don't for a moment think that the Supreme Court's going to ride in on a white horse and is going to save us. The Supreme Court's not riding in to save anyone except its own prerogatives and privileges. These are 9 unelected elite lawyers, 6 of whom are hardcore conservatives and hypocritical originalists, 3 of them put on the court precisely by the man whose culpability is now in front of them. And you have one, Clarence Thomas, whose wife is also an insurrectionist and has no business deliberating on these cases at all. So this is pretty awful, the situation that we're in right now. And we have to understand we've got to save ourselves. And you can vote for Joe Biden and you can demonstrate against all sorts of things that he's doing at the same time. And that guy can be pressured. I think that the uncommitted vote, the movement that's going on now, is actually quite healthy. And it tells him that we don't support what you're doing in Gaza and maybe in a few other areas, but we're not going to go over to Donald Trump. And that's the smart thing to do, in my view.
Absolutely. Well, Bill Blum, once again, you've really put a light on some things that for many people is very cloudy, it's very murky, but you make it very clear. Thank you for joining us, and we look forward to hearing from you again really soon.
It's always great to be with you, really.
Yeah, thank you, Bill. Thanks a lot.
Thank you for sticking around. If you like the LA Progressive content and the discussions we have here, please consider clicking the subscribe button below and also give us a thumbs up. That helps to grow our audience by feeding the algorithm, which helps to get this content in front of more eyes. Thanks for stopping by. We really appreciate your support.